How to fill in the preliminary hearing agenda. We will now go through each section of the agenda. If the employer is represented, you should receive a filled in form and you will be asked if you agree with the respondent. This lecture will assist you to understand what is included in the agenda. As you can see, this is a copy of the agenda for case management at preliminary hearing. First section is about parties. Section 1.1. When this question is asked, this means whether the names of the parties are correct on the ET1 claim form or if submitted by the employer the ET3 response form. Sometimes the claimant is not aware of the correct legal name of their employer and do not know whether they are a company or a sole tradership. You can find your employer's correct name in the contract of employment or any letter you may have received from your employer. Generally, it would be a legal entity, for example, a company registered at the company's house. It may very well be that you have only known your employer by name, a specific individual, and you might have thought, well, they are your employer. Well, they are not, because it is usually a legal entity or the company that is your employer. Although this does not mean that a specific individual or person cannot be your employer, because if they're a sole trader, then an individual can be named as an employer. They might be trading by a different name. If the names of the parties are incorrect on the ET1 claim form or on the ET3 response form, please state the correct name here in section 1.1. 1.2. Should any person be joined or dismissed as a respondent? If yes, why? Given that the hearing is still at a preliminary stage, the Employment Tribunal may allow your application to join another person, for example, a director or a manager, or another company as a respondent. For example, the company you brought the claim against has been taken over by another company, or you believe there has been a 2P transfer, or the business was sold to another business and you are not sure who is the correct respondent. In this case, you will have to apply for the new company to be joined as a respondent or a new individual. Answer could be, yes, I would like to add such and such limited as a respondent. I was unaware that this company has now taken over my previous employer and may be appropriate respondent in this case. Section 2, about the claim and response. Here in section 2.1, you are being asked to summarize or clarify your complaints or claims you brought against the respondent. Put all your claims here, just the heading. You do not need to provide details of your claim. You can state, for example, unfair dismissal or wrongful dismissal or detriment suffered as a result of making a protected disclosure, for example, a whistleblowing complaint, sex discrimination, or areas of pay, or holiday pay or notice pay, for example. If you wish to withdraw any claim, state here. As you can see, it asks if any are withdrawn, say so. For example, the employer has paid your notice pay, areas of pay, and holiday pay since you brought your claim and you do not wish to proceed with these claims. You can state here that you would like to withdraw your claims for areas of pay, holiday pay, and notice pay. If this is the case, these claims should not appear in the list. You can state that the respondent has paid these amounts. Section 2.2. Is there any application to amend the claim or response? If yes, write out what you wanted to say. Any amendment should be resolved at the PH, not later. This is your opportunity in this section 2.2 to request amendment as a claimant if you are of the view that important claim is missing or you realized that you were not paid your wages in full, or further details which are crucial to your claim are missing. You can also request whether you wish to bring sexual harassment or victimization claim, for example, in addition to sex discrimination claim. If you leave your application to amend your claim too late, you may not be allowed to add anything later, and you will not be allowed to rely upon any new facts at the main hearing. However, you do not need to provide every little detail in the amendment. You may prefer to save some details for witness statement or for the main hearing. But remember, If you fail to mention anything that is important or crucial and does not cover in the your main argument, you may have difficulties to persuade the tribunal at a later stage why you failed to mention this important piece of evidence. For example, you can state, after my dismissal in commas on 18th of November 2020, I ran into my manager in ESDA car park and he said if you had not raised a complaint about sex discrimination, you would still be employed with us today. This will class as victimization and you may wish to add this to your claim. Given that this new complaint arose after you submitted the claim form, the employment judge should allow this new claim to be added as long as it is within the relevant time limit, which is 3 months less 1 day. If the tribunal is of the view that the complaint is out of time or this is resisted by the respondent, the employment tribunal may order another hearing to decide why you should be allowed to bring a new claim out of time. Section 2.3. Has any necessary additional information been requested? If not, set out a limited focused request and explain why the information is necessary. If requested, can the relevant information be provided for the PH? If so, please do. Of course, this whole form is being addressed to both parties, the employee and the employer. In section 2.3, you can set out any request here. For example, any important document that is in the employer's possession or any further information that is relevant to your claim. Given that this agenda is usually required to be sent to the employment tribunal 7 days before the hearing and should be agreed with the respondent a few days before that, it is likely that the respondent agrees to providing this information at the PH or before. Section 3, Remedy. 3.1, 3.2, 3.3, 3.4 and 3.5 are all remedy related questions. In section 3.1 here, you state what you have stated in your ET1 claim form or can add to that if the amount has changed. Provide figures in respect of all your claims here. That is the compensation that you believe you're entitled to. For example, basic award, £5,250. Compensatory award, £8,500. Injury to feelings, £18,000. Aggravated damages, £5,000 for example, or failure to provide written statement of employment terms and conditions, normally 4 weeks pay, for example £2,500, or loss of statutory rights, £1,250, 2-week pay, for example. Please refer to the section where I have provided a template for your schedule of loss for further guidance. Section 3.2. Here you give the total figure of the monetary part. For example, the total on the basis of section 3.1, the amounts that we just mentioned would be £39,370. Section 3.3. If you have already prepared your schedule of loss, please attach your copy with this agenda. I have provided a template of a schedule of loss that will show you how to include different losses. Please refer to the section where I have provided a template for your schedule of loss for further guidance. Section 3.4. Has the claimant started new work? If yes, when? If you have started new work, provide the details here. This may assist the respondent and the tribunals to assess your actual losses. For example, if you got a job soon after your dismissal which paid equal or higher rate, your losses may be very limited. If you try to seek a new job, and some employees may hesitate to provide this information at this stage, and some may choose not to provide this information, and this is your obligation to mitigate your losses. If you haven't started new work, you do not need to provide information here. Section 3.5. In this section, you will need to provide your pension information here. If you do not now, ask your employer or its legal representative. This is section normally which is filled in by the respondent because they have all the relevant information. In any event, you can ask your employer or your employer representative for further information. Section 4. About the issues. Section 4.1 asks what are the issues or questions for the tribunal to decide. Issue is a dispute that the employment tribunal is required to decide between the parties. These issues can be factual as well as legal. For example, did this happen on such and such day? And then also legal. Does this class as unfair dismissal, or is somebody entitled to bring unfair dismissal claim if they have less than 2 years service? There can be a number of factual disputes between the employer and the employee. However, you need to consider the main factual disputes. For example, you dispute that the investigation process was fair, and this was in fact motivated by a discriminatory behavior of one of the managers. The issue would be whether the investigation process was unfair in that it was motivated by a discriminatory behavior of Mr. B. And that is what needs to be stated here in this section. The other issues could be around other complaints of unfair dismissal or discrimination. For example, whether the claimant was dismissed fairly. Was there a genuine redundancy situation? Was Ms. P employed in the same position and on the same pay rate soon after the claimant's dismissal? Did the manager make the following remarks to the claimant on or around 18th of November 2020? If you had not raised a complaint about sex discrimination, you would still be employed with us today. Because you see, the respondent might deny this allegation. So this is an issue between two parties. The tribunal has to decide whether these words were said or not. Next, is the claimant owed holiday pay? If so, what is the amount? Again, if that is disputed. The respondent may also include their own issues. For example, the respondent takes a point that the claimant contributed to her dismissal in that she was rude to her manager and made inappropriate remarks. The respondent may include the following issues. Did the claimant contribute towards her or his dismissal? This is important because if the tribunal finds that the claimant contributed to her or his dismissal by 40%, this means the claimant's compensation will be reduced up to 40%. Employment Tribunal generally adds legal issues, or the respondent does so if legally represented, and they will be covering the legal issues. Section 4.2, are there any preliminary issues which should be decided before the final hearing? If yes, what are those? Can they be added to this preliminary hearing? If not, why not? There could be a range of preliminary issues that may need to be decided before the final liability hearing. This section is mainly relevant to the respondent, as it is the respondent who may request a preliminary hearing. Those issues may include the following. If the claimant has claimed disability discrimination and the respondent disputes that the claimant has disability, under the Equality Act 2010, the Employment Tribunal may order that a hearing should be held to decide the issue of disability. If the claimant is successful, then she can proceed with the disability discrimination claim. You have to have disability under the Equality Act before you are qualified to claim disability discrimination. However, if the claimant is unsuccessful on this point, on the disability point, he or she will not be able to proceed with the disability discrimination complaints. This would not have any effect on the other complaints. For example, you have also brought general unfair dismissal or holiday pay claim. They will proceed as normal. If the claimant has brought unfair dismissal claim, however, the respondent disputes that the claimant was an employee and hence entitled to bring unfair dismissal claim, the tribunal may order to decide the employment status of the claimant first. The claimant will only be allowed to proceed with the unfair dismissal claim only if he or she is held to be an employee of the respondent. One of the most important issues can be the time limit. If the respondent disputes that the claim was submitted within the relevant time in respect of all or any of the claimant's complaints, the tribunal will order usually a preliminary hearing to decide time limit issue. Generally, these issues cannot be added to the hearing unless there is sufficient time and all parties have had sufficient notice, which is normally 7 to 14 days. This is because the parties may wish to submit documents as evidence and witness statements. The claimant may wish to produce evidence for why there was a delay to submit the claim. For example, the claimant was too ill to submit claim and there is a medical evidence to that effect. Let's look at section 5 about preliminary hearings if further are needed, for example section 5.1. This is just an extension of the point 4.2 and details should be provided here. Further, case management orders are usually made at the conclusion of that hearing if it is held. Usually the employment judge will assess how long is required to hear the case. However, parties are invited to comment and feel free to state if you believe your case may take longer than what the tribunal suggested, or you may need less time. Section 5.2 about further preliminary hearing if required. This is again repetition of the points made earlier. However, either party can clarify the position here again. Section 6 about documents and expert evidence. Section 6.1 is about list of documents. Generally, documents are not exchanged until the case management orders are made. If there were earlier case management orders which were made by the employment judge, please put the date from those orders. If for some reason or because there were no case management orders, you may also like to request a date 4 weeks from the preliminary hearing so that you have sufficient time to gather your documents and prepare the list of documents. For medical records, this might take some more time and you can request the judge, say for example 6 weeks or 2 months, to provide those documents to your employer. The tribunal will be giving you this time in any event, and the respondent is also likely to agree with this date. They may in fact request longer dates. Say your preliminary hearing is taking place on 20th of July 2021. You can put down the following dates in section 1. List of documents to be exchanged by 20th of August 2021. So 1 month after the preliminary hearing that you are currently attending. Section 6.2 about documents or copy documents exchange. This is the date when you should be exchanging copies of the documents. Normally electronic copies in PDF format or as attachments to email should be fine. However, you may also send the documents in physical format in printed copy and post them to the respondent's representative. You can give dates for the exchange of documents here. If it is for 2 separate hearings, you can give 2 separate dates according to how far apart the 2 hearings are. The date for the preliminary hearing will be earlier. As a practice, this should be further 1 month after the exchange of list of documents, for example 20th of September 2020, so that you have again sufficient time after the list of documents, although at the time you prepare your list of documents, you would have all the documents in order, but then again, it gives you sufficient time if you want to arrange any post, for example. Section 6.3. Generally, respondent's representative, that is your ex-employer, representative will take this responsibility, and the employment tribunals will order the respondent to prepare the final bundle. You need to make sure that the respondent's representative include all the documents you wish to include in the bundle and nothing important is missing. The following dates can be put into this section. Finalization of bundle, for example 20th of October 2020. Bundle to be sent to the claimant by 27th of October 2020. You can request the respondent to send you a physical copy of the bundle. This is because it is easy to go through the bundle and highlight the documents. You can ask for this in addition to the electronic bundle. Section 6.4. If medical evidence is required, please say so. This is usually relevant in the case of disability discrimination and dismissals due to ill health, etc., or where dismissal is for some other reason. Or you want to submit medical evidence of how any harassment or victimization or discrimination impacted you mentally or physically. Or if you believe that this claim has something to do with your illness, for example, then you can say that you need to submit medical evidence here. The respondent usually requests medical evidence in case of disability discrimination claims or claims due to ill health. Please note that receiving medical records, etc., takes time, and you should ask the tribunal to give you longer time to provide the medical evidence. Sometimes an expert needs to be instructed, for example, whether the claimant has a disability. The costs for expert are usually shared by the parties, is usually discussed with the tribunal, and tribunal may order expert report. Section 7 is about witnesses. It is common, looking at section 7.1 first, it is common for the claimant to give evidence on his own behalf. The tribunals are aware of this, as this is very common. However, if you are of the view that a work colleague or other employees may be able to give evidence for the relevant issues, you may put a formal request to them. A lot of people, in my experience, hesitate if they are not employed by their employer anymore. They hesitate that nobody will come forward from their ex-employer's organization to assist their case. But this may not be the case. There might be someone at the employer who may be willing to assist your case and give evidence in support of your case. So there is no harm in checking with any of the witnesses or some of the witnesses you believe can give evidence. There is a separate section on how to call witnesses, what happens if some witness is not willing to come forward. Please refer to that section. If your colleague is not able to come because of the fear to lose the job, you may consider getting witness order from the tribunals. Your colleague can show that letter to the employer and may avoid adverse consequences. Clearly, your colleague would be under the tribunal order, and if he or she fails to turn up, he or she may be held in contempt of court with serious consequences, which include imprisonment. You need to state in this section why those witnesses are needed and which aspects of your claim their evidence is going to be relevant to. Section 7.2 about witness statements exchange. Generally, witness statements are exchanged simultaneously so that the other party does not have opportunity to know what was written in the witness statement of the party. Depending upon how far the hearing is, ample time is usually given for the exchange of witness statements. If the bundle, for example, is to be received by the 27th of October 2020, witness statements can be exchanged on or before 20th of December 2020 or even later, provided they are not exchanged less than a month before the relevant hearing, so that parties have documents and witness statements in sufficient time before the start of the hearing. Respondents usually call the following two main witnesses: disciplinary hearing officer and appeal hearing officer. If there are discrimination allegations, the alleged discriminators may also give evidence. Investigation officers may also be called to give evidence. Section 8 about the hearings. Section 8.1 about the time estimate for final hearing with intended timetable and if a separate hearing is needed for remedy. First, section 8.1 time estimate depends usually upon the issues to be decided, the number of witnesses, and the number of documents to be reviewed and read by the tribunals. If the claimant is successful, then the tribunal will need to decide what award or compensation should be made to the claimant. In straightforward cases, no separate remedy hearing is needed. However, where discrimination allegations are involved and the compensation is relatively higher, a separate remedy hearing may be necessary. If there are 3 to 4 witnesses, time estimate is usually minimum 2 days. In discrimination cases, time estimate is usually minimum of 3 days. If you are of the view that your case is particularly complex, there are more than 3 witnesses involved, and the compensation could be high, you may request a separate remedy hearing. The downside to that is, if you have separate remedy hearing, given how busy the tribunals are, you may have to face significant delay for the remedy hearing. Section 8.2, dates to avoid with reasons or to list any dates pre-listed by the tribunal. In the current circumstances, you need to provide your dates to avoid for yourself and your witnesses, if applicable, for at least next 12 months. These are the dates when you may not be available due to care responsibilities, for example, or you will be on holiday. Section 9 about other preparation. Section 9.1 about admissions and or any agreed facts, if so, by what date. If you agree to certain facts, you may say so. For example, a certain meeting took place, although you dispute what was actually discussed in the meeting. However, given that there is a dispute in relation to most of the facts, parties tend not to fill in this section. They say simply no or not applicable. Section 9.2 about cast list. What is a cast list? Cast refers to the main individuals involved in the hearing and about or from whom the tribunals may hear. A cast list can be prepared and provided to the tribunals. A cast list will include the following. For example, Mrs. Hoyle, the claimant; Mr. O'Kane, the claimant's representative; Ms. Sharma, disciplinary hearing officer; Mr. Gunyan, appeal hearing officer; Mr. Haynes, investigation officer; or Mr. Smith, respondent's legal representative. You can provide important detail about the individuals if you wish so. However, this must be brief. For example, Mr. Sharma was also present at the appeal hearing. This can be agreed, and usually respondent is ordered to prepare a cast list. Section 9.3, should there be a chronology, from whom and when? Chronology is also useful, and the tribunals may direct the respondent to prepare a chronology. This can be agreed and usually include facts which are not disputed. They are in date order. For example, the claimant started employment on 3rd of January 2019. Disciplinary hearing took place on 5th of March 2020. The claimant was dismissed on 10th of March 2020, and number 4, so on. Chronology, as stated, is in date order. Section 9.4, special requirements. If you require interpreter or any reasonable adjustments, please write down here. For example, you may need regular breaks. And the final section, penultimate section, judicial assessment, judicial mediation. Depending upon if you are interested in settling the matter, you may indicate accordingly. You can also check our section on alternative dispute resolution, that is in relation to how to settle cases and what is involved. There's also a template for Court 3 agreement. And final section 11, any other matters. Any other matters you need to highlight and are not covered above, you can write them down here. I have never seen someone filling this part in. However, this does not mean you may not have something to say for this section. Thank you very much for being with me for this lecture. Now we will move on to our next lecture on what are open preliminary hearings, and then we will move on to case management orders. See you in the next lecture.